State of the State of Ohio versus Noel Nelson, case number 25CR795. The defendant is present with counsel Greg Roby here today for sentencing hearing. We were last before you on November 12th, and at that time the defendant pled guilty to count 1, trafficking in a fentanyl-related compound, a felony of the 4th degree with a forfeiture specification, to count 4, trafficking in cocaine, a felony of the 5th degree, and to count 6, trafficking in cocaine, a felony of the 5th degree. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed, and the defendant has 7 days of jail time credit.
Mr. Roby, any reason not to go forward with sentencing?
No, sir. We're prepared.
Anything you want to say on behalf of your client?
Yes, Judge. Thank you very much. I would just echo some of the things that I talked about in the sentencing memorandum that I filed. So Noel is before you today. He's 36. He lives in Cleveland. He's got a stable home. He lives with his partner. They have a good relationship. It's a stable relationship. He's got plenty of family present in courtroom today, 3 of his sons. He has custody of 2 of those sons and worked hard to get that done. He does have a stable job working at a cleaning company. He's worked there for over 3 years. It's not glamorous work, but it pays the bills for him. There's no dispute he does have a prior criminal history. By my reading of the records supplied by the government, it looks to me like the last time would have been approximately 2015, 2016 for a felony offense. So it's been almost a decade. I don't think there's any great dispute as far as the facts involved here. After Noel experienced the death of the mother of one of his sons, he started battling and wrestling with depression, fell into using drugs. No dispute as far as the facts. There were 3 separate sales to an informant, small amount of drugs. He'll be the first.
It wasn't a small amount of drugs.
Pardon me?
It wasn't a small amount of drugs.
Relatively small, Judge.
Well, maybe for your cases that you handle it.
I suppose we all
look.
Right.
Good.
I digressed. I would say that he's the first one to admit that he made some poor choices in trying to earn extra money to support his own habit and the burden of now having children under his roof. I think his letter speaks to that. I think he's very plainly and he's honest, says what happened. I would ask the court to consider that he's accepted responsibility without issue. I think there is genuine remorse. I think you're going to hear that from Noel here today. He knows what he did was completely unacceptable. He's never came up with excuses. I would ask the court to consider there's family support, the letters, and the people who are here today, his job, his home, his relationship, his family give him plenty of stability, and those are the tools that I think that he can use to succeed if the court would give him the privilege of community control. And that's what I would request. Thanks.
Thank you. Mr. Nelson, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, I would like to say that I made bad decisions to put my kids in harm's way, me not being in their life, and I accept whatever that comes with the choices that I make going forward. I just want to do better because my kids need me there, and they all I got. I'm all they got. That's it.
Thank you, sir.
Thank you.
Mr. Roby, anything else on behalf of the defense?
No, sir. Thank you.
Thank you. Ms. Bell for the State of Ohio.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and based on the review of that report and the memorandum filed by Mr. Roby, the state is recommending community control in this case. Thank you.
Thank you. I reviewed the pre-sentence report and investigation. Drug and alcohol evaluation. I have considered the facts and circumstances of the offense involved, the nature of the offense involved. I received and reviewed the sentencing memorandum that was filed by Mr. Roby on behalf of his client, along with the letters in support of the defendant. Now, considered everything said here today, all this is considered by the court in light of the purposes and principles of felony sentencing which are set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes the commission of these offenses. As for the recidivism factors, the court notes the defendant does have criminal history which dates back 20 years, starting as a juvenile. Juvenile delinquency adjudications and then becoming an adult have continued. Got at least 3 prior felony drug charges, convictions on his record. 2 of them involved trafficking. The latter happening in 2015. Defendant has been on probation before and has violated his probation, so the factor of not complying with previously imposed sanctions by courts is present. Under 29-29-12E, that it does appear to be genuine remorse. Under 29-29-13B1, the court notes strike that. None of those factors are present. The court finds at this point that prison would not be consistent with the purposes and principles of sentencing despite the defendant's history. But as noted by Mr. Roby, the last offense was 10 years ago. Felony offense. There's a couple, I think, open containers since then, if I'm remembering correctly. And the court finds the defendant is amenable to available community control sanctions. So I'll give you a chance on community control sanctions. I'm going to order that you be placed on community control sanctions for a period of 2 years on each count. Those will be concurrent. I'm going to order, however, that there are some consequences involved here. You're going to be ordered to serve 60 days in the Lake County Jail. You have credit for 7 days you've already served. While in jail, I want you to enter and successfully complete the jail treatment program during the last 30 days. Again, successfully complete that program. Follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol. That includes no marijuana use. To submit random urine screens, they have to be negative. A positive screen is a violation. You can't tamper with urine samples, bring in fake urine, someone else's urine, anything like that. That's actually worse than testing positive in my view. You're to attend 3 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. You're to obtain a mental health evaluation and follow whatever, if any, recommendations are made. If they believe you can benefit from any type of counseling or treatment, medication, whatever the case may be. If there isn't anything, then there isn't anything. But if whatever recommendations are made, you're to follow those recommendations to help you with some of the issues that you discussed, which led you to getting back to where you are here today. But the plan is to get you back to where you were before that, and where you were for the last 10 years. So that's the point of all this. You to pay court costs and supervision fees, in order the forfeiture of the contraband and instrumentalities. I'll dismiss counts 2, 3, and 5. bond will be released if any bond is posted by the defendant. Derek, anything else I should be considering or thinking about?
No, Your Honor, thank you.
Mr. Nelson, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, you leave Ohio without permission from the court, or if you commit another offense while on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you did violate, I could extend your probation up to 5 years, can impose more restrictive sanctions against you, including jail time, or I could terminate your probation and send you to prison. 1 second. And if I sent you to prison, it would be for a term of 18 months on count 1, 12 months on counts 4 and 6. Those would all be served concurrent with each other for an overall prison term of 3.5 years in prison. That could also be consecutive to any other prison sentence you may be serving if there's some other case that occurs or that you're being sentenced to at that time. All right, Ms. Bell, anything else for the record?
Nothing further, Your Honor. Thank you.
Mr. Roby?
No, sir, thank you.
All right, thank you.